Thank you, Chairman. There is a matter which urgently requires explanation, both for legal and political reasons. At the last meeting of this committee, it was admitted that the triumvirate had no mandate. Yet press releases are being issued which describe them as Parliament's representatives, reinforced by Mr Gualtieri just now, who has described himself as a negotiator. These two statements are mutually exclusive. They cannot both be true. Information to hand suggests that the Conference of Presidents in December was responsible for these individuals being thus designated. I hesitate to use the word appointed, since that would imply that this was a legal act. For once I find myself in agreement with Mr Martin Schulz, yes really, who said to the German paper Spiegel Online in December that citizens are fed up with having everything decided behind closed doors. Well, isn't this hypocritical? Because he was present at both these Conference of Presidents meetings where they discussed the idea of designating some MEPs as negotiators. This sort of stitch-up is typical of the undemocratic ways of this Parliament. Without any reference to the rest of the 740-odd MEPs, a small group of people affects to act on our behalf, and with our consent, by appointing these people to act. One is surprised to see even that the leader of the Conservative Party in the EP participated in the second round of these meetings. As it is, this small elite group has chosen a completely partisan team of convinced federalists to take part in this exercise. The contempt for Parliament and for the voters of Europe is there for all to see. This is a matter which is of such great importance that it ought to have been put to the whole membership of Parliament for debate, not least in the interests of openness and transparency. But perhaps most importantly, because there appears to be no legal basis at all for the involvement of Parliament in this matter. Is not the reality that in the absence of approval from the whole of Parliament, they have, as was admitted last week, no legal standing at all? Is it not the case that these people represent legally nobody but themselves and their constituents? This is but one aspect of the legal basis for Parliament's involvement. On the face of it, the real victim of this exercise is the rule of law. This is not an EU treaty. How then can the Parliament in its own right be legally involved in this matter when this international agreement is not an EU treaty? And I am so disappointed that Mr Verhofstadt is not here, because I want him to answer the question that none of you will answer. What is the legal basis for this committee being involved so intimately with something which is a matter only for the group of countries numbering anywhere between 17 and 26? What authority is EU taxpayers' money being spent on something outside the Parliament's remit? This is not going to go away. The rule of law must be upheld. If you are not prepared to obey the rule of law, then we will challenge you. You may be high, but you are not above the law. And if these two committees should be discussing anything at all, it should be how to extricate Greece and others from the euro with dignity. Thank you.
Thank you very much. Okay, I think we can now ask Mr Romero to take the floor and to answer some of the legal points that have come up. We'd be very interested to hear.
Merci, Madame la Présidente. Si vous...
Thank you, Madam Chair. If I may, I won't just deal with the strictly legal points. I'll say how in the Commission the current situation is viewed. President Barroso had the opportunity of expressing himself before the plenary in December, immediately following the European Council meeting of the 9th of December, and clearly expressed his view that the Commission wasn't in a situation which could be seen as ideal for us. We took the decision of heads of state and government as being something which had to be seen as a fait accompli. You all know why. Because the member state refused to make progress on the path of revising the treaty. The Commission would have preferred to directly change and revise the treaty and change the qualified majority, for example, from 126 and have a qualified majority, a reverse qualified majority, which you now have as a commitment in Article 7 of the agreement that you're discussing. The Commission would have preferred to have seen Article 126(10) fall and for there to be infringement procedures for excessive deficit procedures. That would have been much clearer in political terms and legal terms too. But that wasn't possible and want us to be able to. The Commission is wasting its current doing. This is a Byzantian debate. We are back to the sex of angels. The Commission is doing what it should be doing. It's acting as guardian of the treaties. It's associating representatives of the member states and representatives of the European Parliament in its work to be sure that in this text there is nothing which runs counter to or contradicts or is not compliant with the treaties. Some of you have said that objectives have been set which are the same objectives as the Commission, to be sure that this contributes to solving the crisis. Now, we know there's not going to be able to solve the situation in one go, but that this has to be a contribution to doing so. And we want to avoid as well the fragmentation of the European Union. We want to avoid there being a series of concentric circles whereby it would be impossible for anyone to know where they are or where they're going. And last but not least, we need to be sure that the community method is as far as possible respected and reflected in the text. I'd say that in terms of the negotiating atmosphere, and I'm sure Mr. Gualtieri won't deny this, apart from the unfortunate surprise that we all had with the version that was distributed for the last meeting, and in particular the institutional aspects, things have been moving in the right direction each time. Maybe not as much as Mr. Gualtieri and myself would have liked to see them do so, but at least in the right direction. Some examples. The treaty now recognises that if there are things that have to be a part of an international treaty, that will happen through secondary legislation. And that secondary legislation will be the only way to develop the objectives and commitments of the contracting parties or member states are moving into in international terms. Now, in the specific case mentioned by various people of the apparent differences between the legislation of the six-pack and the objectives and commitments that the contracting parties are setting now, I am confident that in the next version the Presidency will pick up the recital that was suggested by the Commission, recognising the provisions of the Member States to adopt proposals that the Commission could put forward in future to ensure no differences between them. But if you read the text of the international agreement, it is clear that now, once this international agreement enters into force, it will be up to the Commission each time to make proposals and to develop everything via secondary legislation. On institutional issues, the two most political ones, I would say, we had the unfortunate surprise that in the second or third version of the text, the participation of the President of the European Parliament, as well as the heads of state of government of the Eurozone, disappeared from the Eurozone summit meetings. Once again, we're confident in the Commission that this mistake, which I think was a deliberate mistake, a tactical mistake, will be re-established in the next version of the text, amongst other things, because it's obvious that without that there will be no agreement. The second institutional point that's also political is Article 13 on the European Parliament and relations with national parliaments. Hand in hand, the delegation of the European Parliament and the delegation of the Commission have defended the fact that the text that was on the table last week was unacceptable. From the Commission, what's fundamental is that these relations must be settled through Protocol 1 of the Treaty of the European Union. You've established rules that were ratified by national parliaments. Those need to be consolidated, and the national parliaments need to be associated in the work under the rules for the protocol that we're all familiar with, and we know how they work. And we need to avoid the temptation of setting up other kinds of structures that could be called a third chamber or others, which would just be a source of confusion and would prevent us from moving in the right direction. Let me conclude with one final reference. Various people have raised the issue of what the role of the Court of Justice is. Without a doubt, this is the greatest paradox in this debate, because suddenly those that were obliged to follow the intergovernmental path have recalled emotionally the advantages of the community method, and they want infringements to be possible as they would be in the community method. They want the Commission to become the agent of the Member States and that there should be penalties. Now, if you look at current treaties, there's a lot to be said there, but this cannot be applied as such. The situation is on the basis of an international agreement that was signed by 26 Member States. Nonetheless, and here Mr. Gualtieri perhaps can check whether I'm right. I did say this at a group meeting. We can do some things. We can see a role for the Commission in this subtle play in Article 273. And even as some delegations wish, we could imagine a penalties system. Then there's something else if there's a consensus around the table accepting that. What's happening is that Article 273 of the treaty has only one legal basis, the legal basis of Article 273 of the treaty, which enables the Member States to attribute to the Court of Justice competence for solving some of its disputes. The text that was on the table last week was acceptable for the Commission, and the Commission didn't suggest amendments, but now some delegations, and that's why I referred to this as a paradox, some delegations want to go further. On that basis, we have to look to see what the role is that the Commission can play in that procedure. And the Commission is prepared to play that. Politically, legally, the Commission is prepared to play a role. But as I've said on various occasions at the negotiating meeting, what is vital is that the procedures that we establish guarantee the independence and autonomy of the Commission. The Commission is the guardian of general interests. It can't act as guarantor of initiatives of a contracting party or a member state or a group of member states against other member states who are other contracting parties to the agreement. Now, I don't want, because it would be superfluous, to praise the work that's been done by your representatives in the negotiations. What I did want to do was to reassure you on 2 points. First of all, even if we're not in an ideal situation, things, in spite of certain changes, are moving in the right direction. At the end of the day, we may end up with a text that plays its role for a given period of time. From the institutional and political viewpoint, and I'll conclude there, Chair, for us, the most important thing is the provision whereby we incorporate this into the treaties in the near future. That is, I think, what we should be aiming at with this text, so that it no longer is problematic. But unfortunately, for the reasons that were mentioned by Mrs. Goulart, at this particular stage, it's impossible for us to have a debate under the normal rules on amending the treaty. Thank you.
Thank you very much.